Hi everyone, in this week's dispatch video we're looking at a client question around searches and specifically whether an employer can conduct routine bag searches on an employee in a retail setting. There may be a suspicion of wrongdoing which has led to this. We may have a randomised process and a follow-on question is what happens where an employee refuses to consent to that search. As you may have gathered from the videos that were prepared in the past, one of the most important places to look is the handbook and the contract potentially as well. So is there a policy in the staff handbook which contains a right to search, and if so, is that policy contractual? If not, really the right to search should be contained in the contract of employment in order to have a concrete contractual right to undertake those searches. That may say something such as that the employer may search its property or an employee's own belongings, or a desk or a locker where those belongings are kept, for evidence of theft, alcohol or drug misuse as an example. So putting the specific search parameters in there and putting the justification in for that search as well. Now there are obvious industrial relations issues which go with that. If a process is not properly randomised, an employee may feel that they've been targeted, an employee may feel that their own personal possessions should not be interfered with, and that can raise human rights and privacy issues. And the employee could go to the extent of arguing that a search that is undertaken without justification or in a disproportionate manner breaches trust and confidence, which can result in a constructive dismissal claim. Where the employer acts in an industry where searches might be quite commonplace, and I'm thinking particularly in the retail sector, it is possible that the employer could argue that there is more justification in requiring searches to be undertaken than in other industries and sectors. But again, if that right is not contained in ideally a contractual document, it may be more difficult to enforce if an employee refuses. If the employer has a widespread problem of theft, for example, again, it may be more justifiable to undertake more regular searches and possibly randomised ones as well, although the question will always be whether or not less intrusive methods can be obtained. So there may be the possibility of some CCTV footage, again, which is not particularly intrusive and which complies with GDPR. And we may limit searches to where there is reasonable suspicion on the part of the employer. So similarly to undertaking email monitoring or perhaps undertaking alcohol and drugs test. Again, if that justification can't be found, it can give rise to arguments that the implied term of trust and confidence has been breached, and that could again lead to some litigation. So finally, what happens if an employee refuses to permit a search? So hopefully in the case of most employers who are undertaking these, they will have a contractual document in place. In those circumstances, where there is evidence that the employee has agreed to that, I think it's quite reasonable for an employer to imply guilt on the part of the employee if they sign up to that policy or requirement and then subsequently refuse to consent to a search, unless they have particular justification for not doing so. If that policy or contractual right is absent, I think it's much more difficult to rely on a refusal as grounds for disciplinary action because there was no basis to undertake that search in the first place. So hopefully that's given you an insight into the world of bag searches and personal property. It is a difficult area because of the competing considerations. If you do need any further support in this area, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.